we're going to go ahead and get started. I want to echo the welcome you received from Paul this morning. I'm Charlie Plumb. I was one of the mediocre attorneys that Paul mentioned. But the good news is we have Elizabeth Bowersox, one of the quality attorneys that Paul also mentioned, that's going to really carry the day in our section. As a starting point, let me ask you, how many folks last night watched the premiere of the television show Fargo? You are kidding me.
It's just you, Charlie.
You are kidding me. You got to catch up. Go see it on demand. It's fabulous, okay? Our section, what we want to spend our section on today is talking about governmental agencies and what you should anticipate for 2014 in terms of issues and activities on the part of federal agencies that are charged with administering and regulating employment issues. So let's start with a trend we're seeing right now, nationally and Oklahoma. We are seeing a very precipitous drop in litigation, in individual lawsuits brought against employers by employees. It's happening nationally, it's happening in Oklahoma. But don't feel sorry for us lawyers, okay? Because at the same time, the lawsuits by individual plaintiffs is dropping when it comes to employment issues. We're seeing an extremely high increase in governmental agency activity when it comes to employment issues. And there's probably a lot of reasons for the decrease in individual litigation. Maybe improved employment and economy generally. We've had some law changes that are beneficial for employers that make it there's less of an incentive for individual employees or plaintiffs' attorneys to sue you. That may be what's going on. We've also seen a ramping up in federal agencies of their budgets. We're seeing more boots on the ground in terms of investigators and regulators. Federal agencies are taking a more robust position in terms of investigations, in terms of prosecution, and they're also, in many cases, taking new positions and making new challenges for employers in the future. So what Elizabeth and I want to get across to you in our section today is in 2014 and bleeding into 2015, HR professionals and employers are more likely to be challenged and face challenges from governmental agencies than they are from an individual suing you. I think that's going to be the reality, and it's going to be the reality for quite a while. And so Elizabeth and I thought it would be helpful to talk about 4 agencies that you should anticipate potentially knocking on your door in the next 12 months. We're going to be talking about the EEOC, we're going to be talking about the National Labor Relations Board, and we're going to be talking about the Wage and Hour Division of the Department of Labor, and closing with OSHA. So with that, let's get started with EEOC. Realize where we're coming from. 2013 was a record year for the EEOC. Record in terms of how much money that agency gained for claimants, over $370 million, either through charges, settling or mediating charges, or through litigation. And they had one of the top 5 years of complaints, discrimination complaints filed, over 97,000. They have launched what they've called a strategic enforcement plan. And what that means is the EEOC put their collective heads together and said, look, we have realistically a limited budget, we have a limited but growing number of investigators, so what are our target issues? What are our target issues going forward? And we're going to talk about that because that's going to be critical, I think, for you to have your antenna up in the coming year. Another thing we should be cognizant of when it comes to 2014 and 2015 and the EEOC is what they call systemic or systematic investigations and initiatives. And here's what that means. Again, with the idea that they are going to target particular issues because of limited resources and bodies and time, they say, look, we're going to keep processing Charlie's individual discrimination complaint. But what we really want to go after, we want to go after employers or employers' practices that affect a large number of employees or candidates. Because we're really going to get the most bang for our buck if what we're challenging is not an individual decision on whether someone gets hired, not an individual decision of who gets promoted or disciplined. But if we find a policy or a practice that employers are using that affect a number of employees, that's really what we're up for. That's what we're going to go for. 23% of the lawsuits filed by the EEOC in 2013 were systemic charges, attacking not individual decisions, but practices and policies across the board, employers employed. And also, they were media-driven, okay? I'm a cynic here, okay? But has anybody besides Elizabeth and I noticed recently how active the EEOC is in getting press releases out when they sue somebody or they settle and get a check? They have become very media-driven. They want to get it out there that they're active and they're successful. They want to generate more work for their agency. So that's the other beauty of the systemic cases. It affects more employees, so they get a better splash. I talked about the strategic enforcement plan. Here are the 5 areas you need to be on point when it comes to EEOC enforcement for 2014. Number 1, and this is in no particular order, and I will tell you, Elizabeth and I came up with this list sometimes from very explicit statements the EEOC has made nationally, and sometimes we're reading behind the line. But these are the 5 issues we think you really need to be sensitive to for the EEOC in 2014. Number 1, pregnancy discrimination. Hot button for the EEOC in 2014, both on hiring and accommodation. They are going to be looking at how employers address hiring people who are pregnant, how they deal with existing employees and accommodating medical complications or a simple absence because of pregnancy. Number 2, disability discrimination. Another hot button for the EEOC in 2014. They have told us that part of that will emphasize, number 1, the very low threshold it takes to be considered disabled for purposes of the ADA now, with the expanded definition of disabled. They're going to be looking at accommodation issues, additional leave as an accommodation, even if someone has exhausted their FMLA. And they're really going to be focusing hard on that very complicated and complex situation where ADA and FMLA overlap. You heard from Paul and Phil and Kathy and Sherilyn about selection and hiring. That is number 3 on our hit parade, okay? They're going to be looking at hiring and selection process. They're going to look at background checks, like you heard in our earlier sessions. They're going to be looking what assessment tools employers are using. Maybe you're using tests to hire people or tests to promote people. They're going to be looking at that to challenge it. Wellness programs. How many folks have a wellness program in place? You know what? Great. Great program. ERISA has been very good about issuing guidelines to explain in the context of ERISA what is lawful and what is unlawful when it comes to including a wellness component of your benefit plan. The EEOC has, in my opinion, purposely left this just a morass, just this black hole, because they want to be able to ambush you to claim that the request you're making for medical information or how you're using medical information is unlawful. It violates the ADA, they say, or GINA, but they won't and haven't yet issued an opinion on what we're supposed to do, okay? I think that's a form of job security. I mean, isn't that great? You're a regulator. Don't tell us what to do. Just stand on the sidelines and catch us as we go down that path. Last issue that the EEOC said they're going to focus on is sexual orientation and gender identification. As we sit here today, sexual preference, sexual orientation, gender identification, they're not covered or protected by Title VII. There's some movement in Congress to change that. They're not covered or protected by our Oklahoma statute, but we've seen the EEOC take an aggressive position and doing what they call stereotype claims in lawsuits. Someone contends that I'm male and I didn't get hired or I didn't get promoted because I wasn't masculine enough, or I'm female and I didn't get hired or I didn't get promoted because I wasn't feminine enough. That kind of stereotyping by gender. Title VII says, or excuse me, the EEOC says, we don't care if Title VII doesn't cover sexual orientation, or gender identity, that sort of sexual stereotyping violates Title VII's sexual discrimination clause. Again, a new development. Elizabeth, would you move us on to the National Labor Relations Board?
Sure, thanks, Charlie. Our next agency is the NLRB, also known as the National Labor Relations Board. And because there's labor in the title here, sometimes people think that this only applies to unions, but also applies to both unionized and non-unionized employees. And what's protected here is any employee's right to work together to better their working conditions. So employees are allowed to get together and talk about the terms and conditions of their employment. And in fact, that's really where the focus is right now from the NLRB, is on non-unionized work environments. For those of you out there who are trying to make sure you don't become a unionized employer, the thing to look for this year is the new proposed rule from the NLRB. This proposed rule would substantially speed up the period of time between a petition and employees being able to vote on union representation. This is kind of called the quickie or ambush union election rule. And what we have now is where it might take, for example, 8 weeks from the time the employees decide they might want to organize to when they actually have that vote. And then under this new rule, that time period might be shortened into as little as 3 weeks. We know from experience that when you have this shortened period, the union is more likely to succeed, because employees don't always have all the facts during this condensed time period. So what that leads to is employers needing to be in a constant union avoidance mode. So what are the hot topics for the NLRB for 2014 and going into 2015? First, we're going to talk about social media some more, because you haven't heard enough about it this morning. But I saw some of y'all checking your Facebook in the back row, so I know that social media is something that we're all interested in, and it's a hot topic continually. So how many of you have social media policies in your work? Yeah, a lot of you. That's great. Social media policies are really important, but what you have is the NLRB cracking down on employers who have these overbroad social media policies. Like I said a second ago, employees are allowed to talk about the terms and conditions of their work. So that includes getting on Facebook and complaining about their job, because sometimes other employees might get on there, make comments. What you've got is sort of collective action going on, even though it's on the internet and not in person like you might normally think of. So if you've got this overbroad social media policy that says, no talking about work ever on Facebook, then the NLRB is going to take a look at that, and they're going to say, this violates the law. And the other issue here is not just the policy, but when you're disciplining employees, maybe somebody says something on Facebook, a customer sees it or a coworker sees it, brings it to you and says, hey, I think it's pretty tacky that so-and-so is talking about their job on Facebook. And, the supervisor might say, what should I do? Can we fire this person? The NLRB frowns upon it when you're firing employees for talking about the terms and conditions of their work, even if that happens on Facebook. So that's one area that you need to be aware of. But it's not just Facebook. It's any kinds of prohibitions in your handbooks or in your policies about employees discussing things. Sometimes this comes up in workplace investigations where you want to say, no talking about what you've talked about in an investigation ever to anyone. You can see how that could be sort of overbroad. Or there's these no gossip rules. One I saw recently was 2 employees should not talk about a third employee's personal life when that third employee is not present. You might think, that sounds like a great idea, because offices are totally rumor mills.
It takes all the fun out of the workplace,
I know, right?
As far as I'm concerned.
I would have nothing to do.
Certainly, it wouldn't work in McAfee.
No, certainly not.
We're backstabbing all the
time. So this might sound like a good idea, but you get into trouble, because what does it mean, their personal life? These people might trying to be talking about the terms and conditions of their work, what so-and-so is getting paid, why this person has better hours than I do. So that kind of thing is just really overbroad, and the NLRB is going to frown upon that. Now, here's a new one, is videos. You might have a social media policy and you think you've covered all the bases because you've got Twitter and Facebook and LinkedIn. But what if you had 4 or 5 employees go and they decide to get a video camera and shoot a YouTube video? And on this YouTube video, they spend the whole time complaining, I totally work in an unsafe environment. And they post it up on YouTube for anybody who wants to see it. And of course, as we know, these things go viral, and there's also a cat in the video, so it gets 1 million hits. And then what do you do? So if some of you are thinking, well, I would fire that employee, just be aware that there was a recent case out of the state of Washington where employees did exactly this. They did a YouTube video where they complained that their workplace was a hazardous environment. They got fired. The NLRB pursued it, and it ended up settling, and the employer had to pay full back pay for each of these employees. So that's the risk you're running if you're doing something like that. The final bullet point, Phil and Paul mentioned this earlier about arbitration agreements. Well, you can completely have an arbitration agreement, and as they said, you can restrict the ability of the employee to participate in a class or collective action, but the NLRB doesn't like this, and they're going to continue to challenge those policies, and we'll just have to see how that plays out in court.
Hey, Elizabeth, before we move on to wage and hour,
Yeah, Charlie.
one point I wanted to make. I encourage you to get a flavor of what Elizabeth was speaking to about the no gossip or workplace conduct rule enforcement by the NLRB. Go to our website and our blog, EmployerLINC.com. You'll find a brief description of 2 cases in which the NLRB ruled that employers, if you can believe this, who had policies that said employees had to be courteous and professional and appropriate towards one another, that those were unlawful. Okay? And here's the other, it makes you feel good about everything, doesn't it? You know? Crazy. Go to EmployerLINC.com and read that. But here's the other dirty little secret, and Elizabeth just gave an example. The NLRB is taking a very aggressive role and an enforcement position contrary to established law on these issues and these policies, and they're betting that you won't spend the time and money challenging it. Because as long as employers don't challenge their rules in courts, they become the rules that govern us as employers. So we're asking all of you to please institute these policies that the NLRB is finding unlawful. Get sued and hire us, okay? And let's take this to the wall together, okay?
Yeah, that's right. We're going to go all the way to the Supreme Court, right? So our next agency is the Department of Labor. Here you've got the Fair Labor Standards Act. This is the law that says you've got to pay your employees overtime, you've got to pay them minimum wage. We talked about earlier the executive order here about exemptions. And I've been talking about agencies, and so has Charlie, but let's switch gears and just mention litigation for a moment. Though litigation may be down in most areas, it's actually shot way up in wage and hour cases. So we see an increase of 16% just in the last year on these wage and hour cases. And these are collective actions where the employees can get together, they can all sue, it can get really big, really fast. And in fact, if you count the collective actions as a class action, which is basically the same thing, then 90% of federal and state court employment class actions right now are on wage and hour issues. So this is a huge area for liability. And what we see is plaintiffs, employment lawyers who are keeping up on the issues. They are going on Pacer, which is a website where you can pull off court records, and they are looking and seeing where have other lawyers been successful in these claims, and then they go out and target the same industries or market areas. So if they see some lawyer just got a huge result in a case which was about waiters and waitresses or servers, or if they see somebody got a huge result for mortgage loan originators, then they're going to go and they're going to target those same kinds of employers in the market. So for you, what you need to make sure to do is to keep up on the news, see who's getting hit, and to be aware when others in your market are getting hit with these lawsuits. Now back to the agency, the Wage and Hour Division of the Department of Labor is who administers this. And as Charlie mentioned earlier, they've got a bigger budget, more field investigators, and they're trying to solicit more claims. They've got a We Can Help campaign, and they're trying to get employees and third parties and unions all to bring them claims. So in the past, they may have just targeted employees, but now they're saying, We want you to tell us when you think your coworker is not getting paid correctly. So we've got a broader universe of people that can be tattling. There's also a smartphone app where employees can keep track of their time and contact the wage and hour division. So the issues here, employees misclassified as independent contractors. I think you've heard us talk about this before. It's a big issue always. What we've got here is agencies that are sharing information. So, for example, you terminate a contract and the individual who thinks you thought was an independent contractor goes and claims for unemployment. And they say, I was actually an employee, I deserve unemployment. And say the OESC agrees with them and says, you're right, you were an employee. What they might do then is give that information to the IRS or to the DOL and say, hey, we think this employer misclassified this person. So sometimes that's a formal way that they share and sometimes it's informal, but you have to know if you're getting hit in one area, it might trickle down. Increased record keeping obligations, right to know rules. This kind of goes back to the we can help thing. And then there's a rule that's being talked about right now where employers would actually have to justify to their employees why they're classified a certain way. So they might have to, for example, hand them a piece of paper and say, you're salaried, you're exempt under the administrative exemption because of X, Y, and Z. Now that's not a rule that's in place yet, but that's one they're talking about. Misclassification of employee as exempt, I think that Paul and Phil covered that for you guys earlier well enough. Auto deduction of time for meal periods. This is actually a common issue where employers, they have a timekeeping software and they say, okay, 1 hour is going to be taken out every single time for lunch every day, noon to 1. But the problem is sometimes employees might work through their lunch break and then they're not being paid for time that they're actually working. So if you've got that kind of software, you've got to communicate with your employees what they need to do if they are actually working during that time and not just automatically take out that time even though they might be working. Remote work, also here the idea of on-call work. Thanks to technology, some of us are more accessible than we want to be all the time, even when we're not at work. So the problem becomes if you've got...
That sounds like a personal observation, Elizabeth, for your own life.
Hey, I'm not saying anything. So what you've got is these employees who are hourly and non-exempt who are working from home, checking their email, responding to messages on their smartphone or their tablet, and how do you know when they should be paid and when they should not be paid? If they say, I'm working from home, how do you actually know they're working, they're not working? It's one of the hotter topics that's going on right now, and you've got on-call issues, same kind of thing. When is the employee actually working when they're on call versus when are they just sitting around not working? And off-the-clock work, what we're talking here is any time where you're requiring your employee to do some work when they're not allowed to clock in. So, for example, at a restaurant, make the servers come in 15 minutes before their shift starts and roll silverware. Or maybe the employee only clocks in when they log onto their computer, but it takes them 20 minutes to boot up their computer every day and they're not getting paid for this. Actually, Amazon.com just got hit with a big lawsuit on this issue because their employees have to go through security on the way in and on the way out, make sure they're not stealing anything from the warehouse. And it takes a long time. They've got to wait in line. They have to get to work 30 minutes before their shift starts. And they're saying, this only benefits the employer. This doesn't benefit me. I should be getting paid for that. So we'll just have to pay attention and see how that lawsuit comes out. Now, my final slide here is 2014 Wage and Hour Division targets. These are kind of the industries that the division is going to target this year. And I know there's a lot of you out there in these industries. We've got restaurants, construction, oil and gas, hotel and tourism, healthcare, janitorial maintenance, food processing, and personnel service. And remember that these are also triggered by individual complaints.
All right, we're going to finish with our good news with Occupational Safety and Health Administration, OSHA, and talk a little bit about what you can expect from OSHA. Again, we think one of the 4 most active agencies you're going to see for the coming year. Here's what they have planned. They're intending to issue new regulations that are going to up the amount of records you're going to be required to keep for on-the-job injury and illnesses and the speed in which those have to be transmitted. They're going to focus on temporary employee safety. OSHA has said, that employers are increasingly using leasing companies or staffing companies, and they're afraid, OSHA, that safety issues get slipped between the cracks. So they said they're going to put a spotlight on leased and staffing employees. I2P2, that's Injury and Illness Prevention Program. That's a regulation that's going to go, it's going to be issued in September. That's going to require you to put together a program, a preventative program, where you're collaborating with your employees to identify potential problems or areas of non-compliance in workplace safety, and require you to work with your employees to prevent it, monitor those efforts. OSHA is having a renewed interest in whistleblowing. There are 22 different statutes that protect whistleblowers from retaliatory actions on the part of employers. They have consolidated the investigation and prosecution of those claims all under OSHA's umbrella, again with an idea of really marshaling those resources and going after whistleblowing claims. Here are their targets for 2014 OSHA. Number one, Site-Specific Target Inspection Program, SST. You can go on DOL.gov and see if you're on that target. The OSHA has compiled injury rates and illness rates using 80,000 employers around the country. They've come up with a calculation called a DART number, and you can go to the website and figure out if you're on that targeted inspection list. They have also said in 2014, 2015, for OSHA violations, we're going to be targeting nursing and personal care facilities. You still are going to be subject to OSHA for employee complaints or severe accidents. So that's what you could expect to get the fickle finger of fate on you from OSHA in 2014. So, what do you do with all this good news? Well, just realize that we are in a target-rich environment. You are the targets. And we have federal agencies who told us they are going to be more aggressive. They're going to be better. They're going to be better funded. So what does that mean for you? The answer is don't be a target. Let somebody else be a target. Understand and recognize the hot buttons that Elizabeth and I have pointed out to you that these agencies are going to be looking at, and do some internal auditing. Be proactive. Use the information hopefully you're gaining from all our speakers today. Look at that. See if you've got any problems in-house before the spotlight hits you. Thanks a lot. We're going to be followed immediately by Natalie Ramsey and Josh Solberg, who are going to talk about another hot topic, and that is retaliation and how to go about avoiding claims of retaliation.
Good morning, everybody. We're just here to continue to bring you the good news of how to not get sued, or to tell you how everyone is getting sued so you can avoid it. We're going to talk about retaliation claims and how to avoid them. And, you know, I'm not going to go back to Charlie. There we go. Upside down. We're here. We talk about retaliation because, you know, statistically, it is the number one race discrimination claim that's asserted year after year after year. And we look at the statistics the EEOC gathers, the stuff that you're looking at right now. 41% of the claims that were filed nationally last year with the EEOC. And here we're talking about things that are going to be like Title VII, age discrimination. There's a whole body of law that the EEOC doesn't track. And I'll hit on those briefly in just a minute. There's a whole body of law they don't track, and this is just the EEOC, and we're still looking at this kind of volume of retaliation claims. They either are going to come in the form of something that's filed in tandem with another kind of claim, and I'll say that's what we see more of, or they're going to be filed independently, and that happens at times as well. In Oklahoma alone, again, the statistic, were 43.5% of those claims that were asserted last year had or were based on, in some fashion, retaliation. You know, why are they filing them? Well, the reality is they're harder to defend. Statistically, they also oftentimes result in they get better results. So there's a higher incidence of prevailing when we're talking about a jury trial, and there's a higher incidence of recovery in retaliation. So when you got a plaintiff out there shopping for an allegation or for a claim to assert in a lawsuit, well, if they can check that box, they're going to check retaliation box. Because sometimes and frequently, you know, we lawyers can get rid of the underlying claims. So when they assert those tandem claims, or maybe a claim for race discrimination or a claim for gender discrimination and a retaliation claim that comes along with it, We can win the day on the race claim. We can win the day on the gender claim, but oftentimes the retaliation claim is harder for us to win the day on. And the reason for that is, quite frankly, it's human nature. The law of retaliation says if you're accused of something, you can't do what people normally and naturally want to do, especially if you've been wrongly accused. You can't react. Short of an apology or clarifying a misunderstanding, there's no striking back. And so what we ask juries to do is to kind of think that our supervisors and our managers and our employees are able to exercise that superhuman strength and not strike back. And so it makes it harder for those claims to be defended. How do retaliation claims arise? Quite simply, an employee has to engage in some sort of protected activity. Now, that can be a complaint. That can be, you may have an employee who was in the break room that overheard some really hairy conversation that they wish they hadn't overheard, and they've been identified as a witness. They get pulled into the investigation. They reluctantly sit down. And the last thing they want to do is tell you that their supervisor said something that they know he or she shouldn't have said, because they don't want to deal with the possibility of retaliation. That person is protected from retaliation. They've engaged in protected activity, even as a reluctant witness that we've pulled them in and asked them to participate and to be a part of the process. If they serve as a witness in a lawsuit, if they are called upon by the EEOC to be a party to or provide information or testimony in connection with an EEOC charge, if they make a complaint, and I say the word complaint, and I mean, you have to use real caution, because it doesn't necessarily have to come in the form of something that comes in that's written down that's very clearly and unquestionably a complaint, so to speak. If they bring an issue to the attention of management that arguably falls into a protected category, they have engaged in protected activity, and that's the natural assumption that you should make. And then the next step in terms of a retaliation claim, an employer needs to respond unfavorably. And our buzzword is an adverse employment action, and the adverse employment action for an employer doesn't have to be a termination, doesn't have to be a demotion, doesn't have to be a shift change, doesn't have to be something that you go, well, readily, obviously, I mean, this was an adverse employment action. Everybody can agree that this would constitute an adverse employment action. The law says that basically anything that serves to deter an individual from bringing an issue to the attention of management that ought to be addressed, anything that is designed to or has the effect of chilling that can be considered an unfavorable act and can be evaluated and can lend itself to the support of a retaliation claim. So, oftentimes we hear somebody's, I took care of it. The supervisor made a threat, said, if you make a complaint like that about me again, I'm going to change your shift and your life's going to get really miserable. But we talked to him, we fixed it, we took care of it. The reality is that supervisor, by making that threat, has engaged in retaliation. The threat in and of itself constitutes retaliation. There doesn't have to be follow-through in order to satisfy this threshold. So we're looking at things that are truly just, verbal threats or commentary. And these are things we have to just watch incredibly carefully. A complaint doesn't have to necessarily have merit in order to be something that can be actionable. So if they come in and they make a good faith complaint about something that they think is wrong, if you're conducting an investigation, you're going to hear more about them. We have to take those complaints seriously. Even the ones when they come in and we think, oh gosh, seriously? Really? We have to deal with those complaints. We have to treat those complaints with respect. Any kind of complaint that somebody makes that they have a good faith basis for believing ought to be protected, even if it would never have supported any kind of lawsuit or EEOC charge or true claim itself. I mean, I'll give you an example. Let's say, for example, that Josh really appreciates his personal space, and Paul's a hugger. I like this. And Paul will routinely come in and he hugs Josh, and Josh just can't stand it, and he's reached the breaking point. But Josh is kind of a shy person. He's rather timid, and he's not real big about taking a stand for himself. And so he goes to Human Resources, and he says, hey, listen, I got to tell you, this Paul guy, he's constantly hugging me, and he's in my space, and I can't stand it. And if you could please just do something to ask him not to do that anymore. Well, Naturally, human resources is going to take this complaint seriously. Are we in a situation where Paul has done something that's going to support a sexual harassment claim or some sort of inappropriate? I mean, probably not. Innocent, hadn't gone on that long. Josh has brought it to our attention. Josh's not brave enough to tell Paul, hey man, back off. I don't want you in my space. But when we go tell Paul, hey, look, you need to stop hugging people, particularly Josh. He's not comfortable with that. He really likes his own personal space. And if Paul gets just furiously angry and is like, man, I mean, he's my bro. What's the deal? And he goes back and he says, Josh, man, I mean, and he blows up at Josh. Paul is engaged in retaliation. When we called Paul in and we talked to him about what he was doing and about hugging people, we weren't bringing him in and reading him the riot act. We weren't writing him up for an inappropriate touch. We were letting him know that he has a coworker that has a boundary that he needs to respect. That was our goal there. We are preventing something from escalating. But when Paul gets mad and can't control his temper and feels like he's been called out and the microscope has been focused to him because of what Josh said, and Josh had a good faith basis for making his complaint, all of a sudden, now we have a real problem with Paul. I mean, Paul could be in some serious trouble. How can we anticipate and respond to retaliation? Education, 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 education. From the moment your employees walk in the door and they get handed our anti-harassment policy and our anti-retaliation policy, some of you I know conduct training, some annually, some more frequently than that, some less, but people need to know. And I think Josh will probably hit it more, but the reality is that every time we're conducting an investigation, from the silly example that I'm talking about with Paul, I mean, Paul should have been told, if we're doing our job, Paul should have been told, look, you can't go out and retaliate against Josh. I wouldn't even mention this to him. Just respect this request and move on. You're not in trouble. We just needed you to understand it. Everybody needs to know that, from the person who's making the complaint, the person who's being complained about, those people who've been called in that are witnesses or that are being interviewed in connection with an investigation. They all need to know that they're being protected, or that they should rest assured that they shouldn't either engage in retaliation and that they are going to be protected from retaliation. You need to know the categories of retaliation claims. From a legal standpoint, in the federal context, we're talking about Title VII. That's going to cover race, gender, pregnancy, religious retaliation. And these aren't necessarily only going to come in the context of somebody making a complaint. Because if I have a request for a religious accommodation and I come in and I let my supervisor know that I'm not going to be able to work this particular shift, and I make this request for an accommodation, I have a legal right to make the request for accommodation. You may or may not be able to fulfill it, but the supervisor cannot retaliate against me because I'm now going to make his life more challenging in terms of managing the schedule, those kinds of things. Can't do it. So we're not just talking about it in the context of people making complaints. Age discrimination in employment. That's the ADEA it's our little acronym. Another thing to recall, you don't necessarily have to be someone who's protected by the statute. Let's say we're throwing a big birthday party for someone in the office and there's lots of over-the-hill references and age-related comments that are flying around. And someone who's not doesn't fall within the protected category of being over 40 comes in and complains to management about it. If they suffer retaliation for the complaint they've asserted, there's the potential there for a retaliation allegation. The Americans with Disabilities Act, same thing. Family Medical Leave Act, that's one of those that the EEOC doesn't track. FMLA retaliation. And we see a lot of those claims where people either make a request for leave or have utilized leave, and then they are asserting claims when things don't go the way they want them to later on down the road, that this is all really just focused on in a retaliatory act because they were gone for FMLA leave. Genetic Information, Non-Discrimination Act, USERRA. USERRA is one, that's a real terrible catalyst. I mean, retaliation, on the one hand, we're trying to ask juries to believe that our supervisors are exercising superhuman strength and they are not doing what human nature would otherwise suggest they would and react or strike back when someone's accused them of something. And you couple that with the situation where we're dealing with a service member, juries really hate those claims. Be very, very careful. National Labor Relations Act, I know you guys have heard this over and over, and again, you don't have to be a unionized workforce for this to happen, and I will tell you, as you've already heard and Elizabeth touched on, so I won't spend a lot of time on it, but Where we're seeing the unfair labor practice charges for those of us who are non-unionized in the retaliation context, or when people are engaging in concerted activity, and we're trying to shut that down. Occupational Safety and Health Act, as Charlie said, they're ramping up their whistleblower claims. It would be really nice if people would bring stuff to our attention and tell us when they think we have safety issues instead of going straight to OSHA, but they have that right. And when they do that, we've got to be very careful. We can't retaliate against them for going around us. We have to respect that they chose that route, and that's what we have to do. Same thing with the FLSA. Gosh, if your paycheck is messed up, if you didn't get paid all the time that you were supposed to be paid for, if there's an overtime issue, if you just come tell payroll, that'd be great. But sometimes they don't do that. State law, Oklahoma Anti-Discrimination Act, mirrors a lot of what we talked about in terms of federal claims. Workers' compensation retaliation, those are tricky. People oftentimes will find themselves hurt at really inopportune times. Documentation is going to be real key when we're going to make decisions in the face of workers' compensation claims, because retaliation claims grow out of our adverse employment actions that might be based on something purely and completely legitimate. But the timing on those can be really, really tricky. And if we don't have good documentation, we probably aren't going to be making those adverse employment decisions when people are on workers' comp claims. Public policy tort claims. The reality is that we've got an argument at least that the OADA is going to take care of those, but we need to still understand that there are certainly laws out there that make things in various different industries illegal, and if people are making complaints about what they believe to be violations in that context, there's nothing that says they can't at least try to run this one through the courthouse still, and so you got to be mindful of that as well. If they're bringing something to your attention, if there's a regulation being violated in some fashion, err on the side of caution and deal with and manage and make sure we warn about retaliation. And with that, I'm going to turn it over to Josh.
Thank you, Natalie. Now is probably not the best time to do this, but I am shy, and Paul, I am tired of you hugging me. Please stop. Immediately. I apologize, the title for this presentation is a little misleading. It's avoiding retaliation claims, and there's really not a way to avoid them. All you can do is prepare for them, and as long as you are an employer, as long as you are interacting with employees and you have HR policies and you are enforcing those rules and you're responding to claims of discrimination and complaints, the potential for retaliation is always going to be there. And so the goal for our presentation, as Natalie had said, is to make you aware of areas where you need to be cautious, where you might need to seek some assistance and be real clear on what the next step is for your plan of action, and then to identify a few key areas where you can try and tackle those claims early on so that they don't become a bigger issue later on by the time they get to litigation. So one way you can do that is policies, procedures, and training. You need to have policies and procedures in place to respond to complaints. Specific to retaliation, there are a few policies that will need to be unique. So Natalie mentioned the Family Medical Leave Act. You should have a provision if you have 50 or more employees and the FMLA applies to you. You need to have an FMLA policy, and within that FMLA policy, you need to have a specific provision that says you are not going to retaliate against an employee for taking benefits under the FMLA. Another example of kind of a unique type of provision would be for those companies that are publicly traded. You should have a code of business conduct and ethics policy that is publicized to your employees. And as part of that, pursuant to Sarbanes-Oxley, you need to have a provision that says we want you to make reports of accounting errors and things like that, things that essentially led to the fall of Enron. We don't want that to happen anymore. We want you to identify those issues, make the proper complaint, and we are not going to retaliate against you. But for our purposes today, focusing on kind of the issues regarding to Title VII, so when an employee makes a complaint of race discrimination, sex discrimination, harassment, something like that, what are the policies and procedures you need to have in place to respond to retaliation in that instance? I would like to have, whenever I'm responding to the EEOC or a plaintiff's attorney, if retaliation is a claim, I want to have a policy that specifically identifies retaliation in the heading. So typically our foreign policy is anti-discrimination, anti-harassment, anti-retaliation. I like to have retaliation specifically identified to show that the company takes it seriously. We need to have a provision that says that within that policy that we take good faith reports seriously and we're not going to retaliate, and kind of set out some of the things that Natalie identified about what exactly retaliation means, and that it's not just an adverse employment action, and that we're not going to engage in those types of practices, and we want to be made aware of it. We want to train our employees on those policies. In litigation, we will undoubtedly get a discovery request from plaintiff's counsel that says, produce all documents associated with your training of your harassment and retaliation policies and procedures. And it is not a good day to respond to that discovery request with the word none, which sometimes happens. Especially in the area of harassment, it is, employers are aware that there's a good faith defense. If you have a policy and procedure in place to eliminate harassment, you encourage reporting and those types of things, that you can get the benefit of this defense. And that is partially true. You also, in addition to having a policy and procedure, you have to have training. You have to be out there telling your employees about your policies and procedures and encouraging them to use them if necessary. And without the training, you don't get the benefit of that good faith defense. And so take the steps. Training is something you can do in-house. You can have your HR department do it. And a lot of times companies have programs that they're paying for already, SAP and other programs like that have with it some kind of electronic training on discrimination, harassment, retaliation, sometimes that you can take advantage of for free that you're already paying for. So one way or the other, you need to be doing training. Specific to retaliation, the two things you need to keep in mind are knowledge and timing. And we'll look a little at that as we go through, but from our perspective as lawyers, when we get a retaliation case, I'm looking at timing. And so if an individual made a complaint and subsequently we've had to terminate them or discipline them, or they've been harassed or whatever the case may be, I'm hoping that timing is more than 3 months out. 3 months is kind of it's not a magic silver bullet. It's not the golden rule, but generally speaking, if I have to terminate an employee after they've made some kind of a complaint or engaged in some kind of protected activity, I'd like it to be more than 3 months out. The other key issue is knowledge. And so if I have a decision maker who is aware that this individual has engaged in protected activity, that they've made some kind of a complaint, I'm going to have a more difficult time defending that case than if my decision maker had no idea that a complaint was ever made. And so that's something that we're going to talk about a little bit more here as we go on. When you receive a complaint, you need to respond immediately. I can't stress that enough. The times we see retaliation cases are the times when employers receive a complaint from an employee, they get a charge of discrimination, and they say, hey, I've got this employee, they're a really poor performer, and I think I need to let them go, and by the way, they made a charge of discrimination the other day. And I say, okay, well, show me the documentation about their poor performance. Well, we haven't actually talked to them about that yet. That's a problem. Another situation is where if an employee has made a complaint and we don't immediately respond, time goes on and other things happen in the course of that employment, as it undoubtedly will, that's also a problem. Before a jury, before the Equal Employment Opportunity Commission or whoever it is that's reviewing your action, the number one thing I want to be able to show when there's been a complaint of discrimination or harassment is that we responded immediately. And how you respond and what you do can vary based on the circumstances. It can vary based on what the nature of the complaint is, who the group of employees are, and there's a number of other factors. But I want to show that we responded immediately. We want to conduct a thorough investigation. Tony and Kristen will be talking today about how to conduct investigations, and so we're not going to get into that. They're going to steal our thunder and make sure you can sleep during my presentation, but don't sleep during theirs. We want to investigate the claims thoroughly. We want to consider separating the complaining worker from the accused in a way that does not invite a retaliation claim. You don't want to come up with the idea, or you don't want to immediately get a complaint and then transfer the individual or take some kind of adverse action against them. But there's a classic situation where the individual works with 4 other employees and they're all related and they're the good old boy club and the individual has made a complaint, and that is a situation where if everyone else is friends and everyone gets along except for the one individual, that situation is probably not going to end well, even if there's not any merit to the complaint. Because especially if it's a small group, it's going to be difficult to conduct a thorough investigation without everyone knowing that there's been a complaint made and that guy's not happy, and now once the investigation is resolved, he's going to go back to work with those same 4 guys. And so if there's positions that are open that we can transfer them to and the individual wants that and they voluntarily ask for it after you've said that's an option, and you can take them through that process and they do it voluntarily, everybody's happy. With one more comment, that even if you transfer that individual or suspend the supervisor or whatever the situation is, you cannot stop your investigation. You've got to complete the investigation, and if somebody has committed a wrong, you need to discipline them, whether it be termination or write-up or whatever the case may be. So even if you can separate the complaining worker from the group, you still need to complete the investigation. Control the information. This is the knowledge issue I was talking about. The NLRA and the NLRB have taken steps to try and limit how confidential investigations can be conducted. We still counsel employers to try and keep them as confidential as possible. And like Elizabeth said, we don't want to have a blanket, you can't tell anyone ever about this investigation. But there's things you should use in that investigation to try and narrow who knows about the complaint and what they know about the complaint, so that later on we can try to avoid a retaliation claim. Those you must tell, you must also warn. You need to have a copy of your anti-retaliation policy on hand when you're conducting your investigation. If you feel like it's an issue and you've got some serious issues, you might have them sign a copy of the anti-retaliation policy when you visit with the supervisor or whoever it is that's going to be in a position to take adverse action against the individual. That's something you might consider. You want to provide a clear and unmistakable directive to the employees that retaliation is prohibited. This is part of a culture within your company. If people are fearful that by complaining bad things are going to happen to them, they're not going to complain. Or when they do, they're going to fear that bad things are going to happen to them. And so when you're investigating and you're meeting with them, you want to go over the top to make sure that they know that what they have done is okay, as long as it is good faith and taken with the right reasons, that they're not going to suffer any retaliation. Timing is everything. If there's merit to the complaint, you want to act swiftly. You want to discipline whoever it is needs to be disciplined. If there's no merit to the complaint, you want to follow up with the individual, say, unless you have anything else to add, we can't find any merit to it. Document it, close the investigation. If you must take action against the complainant, then use caution. Again, closer in time to the complaint, the bigger the issue. We like to see more than 3 months, kind of as a general rule, something to take into account. If somebody is going to take the adverse action, if somebody is going to terminate them, you prefer it to be somebody who doesn't have knowledge of the complaint. I'm about a minute 50 over, so we're going to take a break. Thank you all for being here today.